Mr. Brown.
Please, court. It was enjoyable to listen to that argument and hear Professor Bonfield again center stage. That was very interesting. My name is David Brown. I'm here representing Att'y Kingery in an ethics appeal. Pretty simple on the facts. We stipulated all of them. I've had the privilege to come up here and argue a number of cases, and have, until this afternoon, never had opposing counsel agree with me on anything, even though she is very delightful and I have many interactions with her. Even she agrees with me that the sanction was too much. She just doesn't agree with me enough. Briefly, the facts, without going through every single one of them. We have a young person who, I didn't know people went to out-of-state law schools, but this one did. She went to Syracuse. She graduated. She came back. She didn't pass the then bar exam in 2001. And basically, she was so traumatized by that experience, she did everything except practice law until 2010. She took the bar exam in 2010 and passed it with an enormous amount of drive and energy to do that. She moved to the Decorah area where she set up practice and was primarily in indigent criminal work, and was doing very well as a solo practitioner, reasonably close to where she grew up. I think she grew up initially in Waverly, went to the University of Iowa, and then she practiced there in Decorah. For reasons that she talked about a little bit in the transcript, and as part of the stipulation, in 2013, she fell apart. My guess is there's a number of members of the bar, certainly younger members of the bar, perhaps older, who are solo, don't have a support system, don't have a law firm, don't have a lot of things there to hold it together, and she admittedly lost it. She had a major depression. She was drinking way too much. She realized she needed help. She got it, thank heavens, got it, but her practice at that point was a shambles. The complaints were filed against her. She didn't respond. I mean, she wasn't taking her mail. So she got a letter from Mr. Harrington's office, certified mail, so that she could respond to a complaint, and she didn't respond to anything. So she had a temporary suspension as a consequence of that under your rules. When we met, and now you have a formal grievance proceeding, the real question was, how do you move forward, not how do you recalibrate what happened in the past, to use the term from your opinions. The basic question was, what have you done? How can you assure the court, who will ultimately look at this de novo, that you have looked at what you've done and taken care so it doesn't happen again? She's had a lot of treatment, inpatient treatment, outpatient treatment, and is basically part of AA and has support network within Polk County. She now lives here. She hasn't practiced law a day since everything melded down in 2013. We recognize that's not a direct credit for time served, so-called, in some of these opinions, but those are the facts. Never had a prior complaint, ever. She's taken full responsibility for what happened. She's not blaming a soul. She knows this is her chance to redeem herself and have a second inning. As I read your opinions, and I tried to read a lot of them again yesterday and today, I realize that you state, we try to be consistent, and there's a range. And then after you say that, you generally say, but we have to decide each case on its facts, and use the word to calibrate what the right sanction is. For neglect, I think the range, as I read these cases, is a reprimand, public reprimand, up to 6 months. In this particular case, the grievance panel hit it with the 6 months. No aggravating facts. She took full responsibility. She didn't misrepresent anything to anybody, and they just went right to the top of the line. We think that was too strong. We think, and in the briefs, I think we make a pretty strong argument that under the circumstances of this case, a public reprimand is sufficient. It is appropriate.
Was there any harm to any clients in this case, Mr. Brown?
Well, that argument is kind of made a little bit by Ms. Quinlan but I don't think she can really specify exactly what the harm was. I mean, were there some delays? Yes. Did she have to get out of some cases so others could take over? Yes. Does she owe approximately $300 to a client when she didn't do some work, and she's offered to certainly make that right? Yes. But in terms of the kind of thing that, at least if you go through the laundry list of cases in terms of
There is
harm.
something in the record about some client being jailed over her conduct. What was that about?
Don't have all the facts, Judge. I do know there was one of the problems she had at some point was she wasn't at the courthouse. She didn't have a separate office. She wasn't getting her mail. She missed some hearings, and that was when I think the district court judge also filed a letter with the grievance committee and indicated that she regretfully had to turn her in.
Brown, let's assume, my recollection of the record is there were two clients, I think, who had bench warrants issued because they didn't show up. They didn't know they were supposed to show up. So assume that that's the case for for the purposes of my next question. You know, the cases in which I think we have imposed public reprimands are cases in which there's usually a single act of neglect, a single matter. In this case, you have, I think, the complicating factor of a much larger number of neglected matters by virtue of what happened, and you have those two instances at least where clients were brought in and put in jail at least for a short period of time, arguably some significant injury to them. Given those facts, the larger number of matters neglected and the two instances of client injury, what's your best argument as to why this falls down into the public reprimand or short suspension rather than 3 to 6 months?
You mean I haven't given my best argument yet? No. In any event, I think one of the factors is, did she misrepresent anything to anybody, which she didn't? Number two, this is an isolated period of time in her life. I mean, this doesn't stretch out as you read some of these opinions where people have had a pattern of practice for a period of time. And finally, this whole idea of alcoholism as a mitigating factor is huge. I mean, it comes up, thank heavens, not too often in these opinions, but I do think while it's not an excuse, it is a mitigating factor going forward. So I think under those circumstances, I do think it's something you could look at in terms of a public reprimand as opposed to, quote, anything involving a suspension.
In your reading of many of these cases, what case do you think that is similar to where we gave a public reprimand?
Well, again, I think I read an opinion you wrote, Your Honor, last week, I think, authored last week, and I think what you said was someplace in there, I can't find a case just like this. And I can't find a case just like this, and I'll be frank about it. I don't have one. I do think you base it on the basic overall facts of the given case. I think you weigh the factors of, was there an aggravating factor? I mean, was there somebody that wasn't forthright? Is there somebody that misrepresented something to a tribunal? Is there somebody that didn't take full responsibility for their acts and move forward or not? And in this particular case, all of those things are on her end, on her favor, for a reprimand as opposed to a further suspension. She hasn't practiced law at all since 2013.
What's the closest case that gets you a public reprimand where there was similar conduct?
Well, in terms of similar conduct, I did notice in Tompkins, which I think you authored, at that point, I think there was an indication in the grievance committee to actually have a suspension. It went up on appeal, and it was actually reduced to a public reprimand, as I remember it. And he had more than one instance of what he'd done and didn't respond to the authorities at all, which I think everybody acknowledges. If you get a letter from Charlie Harrington, you probably ought to answer it and probably move forward. That's why we have the rule.
Mr. Brown, is suspension for the failure to respond to the complaint a mitigating factor in the final disposition of the case?
I can't find a case that says that either, although I do think the fact that she hasn't practiced law at all since 2013, the reason I think that has some effect is, what did she do with her time off? did she kind of sit in the corner and basically complain that life didn't treat her so good and maybe she should be doing something else? She actually took the time to really turn her life around and do the kinds of things that, frankly, I guess we wish more of the people that come through our doors and more of the people that appear before you would do. But she has a certain amount of self-awareness about a lot of this with a support network. When she got the ruling, you notice a couple other things. The ruling says you can only practice, but you have to have a mentor follow you around because we want to make sure there's a supervision. I think your opinions, on this, I could cite a number of them, I think make it indicated. We don't have that procedure because we don't know how we regulate it in terms of we're just trying to set up a mentorship program in the Iowa State Bar right now in its infancy. So how do you use that as kind of a sanction? As far as reporting in terms of her mental health status, making certain that she is compliant with what she should be doing as an individual going forward, certainly that's understandable, and we would want that, and she would certainly be more than willing to do that. She loved practicing law. She loves being back here now, where she basically has a support network, and she's in a position she believes to make a contribution to the profession going forward. I see my time is up.
Thank you, Counsel. Ms. Quinlan.
May it please the court, counsel. The board proposes a 90-day suspension, and the conditions of that 90-day suspension would be for Ms. Kingery to provide medical documentation regarding her maintaining sobriety, complying with any mental health treatment or recommendations, and any alcohol treatment or recommendations. It would also, the board would like to see that she continues to cooperate with the director of the Lawyer's Assistant Program, Hugh Grady, and then to reimburse Doug Corson, her client, for $347. One of the things that the 90-day suspension will get Ms. Kingery is past the 18 months of sobriety that she's experienced so far. She testified at the trial that that was the longest time that she had ever been sober, was 18 months. At the time of the hearing, that was 10 months, and now we're sitting at 15 months. So there is kind of a beauty, if you will, to the 3-month suspension that would get her past 18 months. I think the key to the 90-day suspension, though, as far as the board is concerned, is that it brings in the requirement of Rule 35.14, and that outlines the procedures for reinstatement. It's not an automatic reinstatement, which she would normally get if it were anything less than 3 months. This requires recommendations from 3 reputable attorneys currently practicing law, and that would be required to be from here in Polk County. One of the things that Ms. Kingery testified to at the hearing was she had not made any contact with any local attorneys here in the Polk County area, and since she had moved back to Des Moines in 2014. I think the opportunity to make contacts with the attorneys would give her, and especially through Hugh Grady, would give her the opportunity to be in contact with attorneys who are in recovery, and give her the opportunity to have those people write letters of recommendation on her behalf. I think the last thing that the court wants, and certainly the board, to place Ms. Kingery back in the situation that she was in Decorah, and that was, and she currently now lives in a 2-bedroom apartment by herself, and she practiced law out of a 2-bedroom apartment by herself in Decorah. She was extremely isolated, and she really had no contact with the legal community there. She's going to return to the practice of law with bipolar disorder, with anxiety, with depression, and as a recovering alcoholic. These are no small matters, and I think that having the requirement of reinstatement that's available through Rule 35.14 has the potential to offer the kind of support that she needs.
Quinlan,
Yes.
yeah, and I understand your points, and they're good and reasonable ones, but we are concerned about being consistent between and among our cases. So, following up on the line of inquiry that some of us had for Mr. Brown, what is your best case to support the 90 days? What is your most analogous case, given that what we have is lots of neglect, but lots of neglect over a fairly confined period of time with an explanation or for the neglect? What's
Well, I would say that
what's
the
the most
Hohen
analogous?
Otto case, 634 Northwest 2nd, 652, that was a 4-month suspension. And, I mean, it's not a mirror image by any account, but there's alcoholism involved, and I don't know that there was the mental health issues in that case. But, you know, one of the things I want to emphasize, though, is I don't think that in a case like this, that you want to take form over substance when it comes to somebody coming back into the practice of law. I think it's very important for the court to step forward, and the rule that requires her to have input from 3 different attorneys in the Polk County area is going to provide support for her.
I understand that as far as the tail end of this, but I guess I'm looking at it from a standpoint of trying to weigh the aggravating versus mitigating circumstances here. And I frankly see a lot of aggravating
Yeah.
and not very many mitigating, you know, the alcoholism and her treatment and subsequent behaviors, all good, all very positive. But I also see a lot of, you know, ethical violations. I do see harm to client.
Yes.
And I can go on, but you understand where I'm coming from. There's
Right.
a lot of aggravating and not too many mitigating here. And if you start lining up the cases like we're trying to do to be consistent, certainly, you know, to me, a 3 to 6 month suspension may be appropriate. I'm not sure you disagree with that. I know you're emphasizing the tail end about the conditions,
Right.
about coming back, and the 90 days accomplishes that.
Right.
But does that really line up, or is it consistent with our cases?
Well, I think it is, and I think when you look at the aggravating circumstances, yes, there was harm to clients. Any client that has to go to jail because they weren't informed by their attorney that they needed to be at court, that's a pretty bad deal for the client, certainly. There was harm to the first client. I mean, it's not as bad as the person people going to jail, but her appeal was, the appeal was delayed when she didn't file a proof brief, and in that was count 1. And then in count 4, there were, she took on a matter that she admitted during the hearing that she was not competent to handle. She did also have a prior admonition in May of 2014.
Don't we historically, I mean, there's delay in almost any one of these ethical cases. Haven't we historically said that's not client harm? I get you with the going to jail part there, but.
No, I guess it's just more, it ended up that appeal was dismissed as frivolous, but it certainly did delay that person's, you know, justice delayed is justice denied, so to that extent. And the person that she represented in the post-decree matter, that went on and on and on for her not to be able to get her file back for months and months, and the client had to sue her in civil court to get her file returned to her. So I thought that was an aggravating circumstance as well.
Counsel, I'm looking at this case as largely a case of neglect,
Right.
with the aggravating circumstance of some injury to
Right.
clients. But in the last 10 to 15 years, I don't find any cases in which we have imposed a 6-month suspension for neglect. Okay, we have some cases involving neglect that get 6 months, but only because there are other kinds of violations like misrepresentation to the court, trust account violations, and the like. So I want you to react to this. I don't see this as a 6-month case
I agree.
at the outset.
I agree.
And so I'm seeing it as something less than that. And then I guess unlike I differ with Justice Zager a little bit, I do see some mitigating circumstances in terms of the the alcoholism and mental health with good aggressive response for treatment, and also significant remorse. I mean, she's said, I was wrong, I did a bad thing here, and she gets it. So I'm trying to figure out where you're allowing her credit for those mitigating circumstances at 3 months.
Okay. I certainly, remorse is, she certainly showed remorse. She admitted to the ethical violations, and she admitted that the alcoholism contributed to her unethical conduct. That's a mitigating circumstance.
And got
Certainly
treatment.
Yes, and
Yeah.
her rehabilitative efforts. But I think prior admonition, this pattern of misconduct that went on from, really, her unethical conduct started in May of 2013, not just the period of time in October and November. That's when she testified that she really crashed and burned due to the alcoholism. But she had matters that came up in the summer of 2013 where she was having problems. And in fact, her medical records indicate that in March of 2013, before any of this got started, she was told to, by her physician, was suggested that she go into detox, and she didn't do it at that time.
Well, let me ask this question. If the purposes of sanctions are to punish, deter, protect clients, and protect the integrity of our profession, and that if she sort of has been in her own self-imposed period of punishment for the last 2 years and has gone through a self-help process, and what's another 6 or 90 days, excuse me, what's another 90 days going to accomplish
well, I think that
after 2 years?
it gives the court the opportunity to see that she's made it past the 18 months of sobriety that she accomplished before. I think that's a big deal. That's protection of the public, and the requirements that go into the 90-day reinstatement requirements, that she reach out to the community and have some mentorship out there just on her own. And if she doesn't, she'll be back. I mean, I don't think there's any doubt about that. But she's going to start practicing with the same problems that she's had. Yes, she's had some rehabilitation, and she has a certain amount of time under her belt. But I think that to protect the public, I think the court would want to have a minimum amount of time when she's already presented that her longest period of sobriety was 18 months. She's not at 18 months right now.
In Schmidt, I'm sorry to make this go longer, but in Schmidt, one of the things we did, we gave a 30-day instead of a longer one. We recognized that he was out of the practice for 6 or 8 months. He went to treatment, and he did all the things that your client, and that's not your client, that Mr. Brown's client did. And I think implicitly you could read Schmidt to say that, if we didn't outright say it in there. And to follow up on the chief's point, you know, she has sort of self-imposed, and we don't really consider it as a mitigating factor, but shouldn't it play into the amount of time we suspend somebody?
I think it certainly can.
And we have the same safeguards, even if it's less than 3 months. I mean, we could require her to have letters and things as a condition to get in, and if the board doesn't object, then she gets in. If the board objects, we have a hearing.
Yeah, I don't think that's, as long as there's are conditions upon her reinstatement, or that if it's going to be automatic, that she's required to have letters and medical proof that she's complied with medical.
We've done that before with automatic reinstatements.
Sure, right. 60 days. There was a case where it was 60 days.
Was her prior private admonishment related? Is it the same type of misconduct? What was that for?
No, it was her prior admonition had to do with her misrepresenting to, she made false statements, or at least misleading statements to the media concerning a client back in, I believe it was March of 2013.
has she maintained her sobriety since her relapse in June of 2014?
As far as I know, that was true at the time of the hearing, yes.
Thank you, counsel.
Thank you.
Mr. Brown, rebuttal?
Your Honors, having a little break, you do get a chance to go try to find a case or two, and if I might cite a couple that I think, at least I think, have some bearing on this. One of them is in Ray Karen Taylor, which 814 Northwest 2nd, 259, and I believe Ms. Taylor actually got a public reprimand, wasn't suspended. Another one that I think has some bearing on this in light of what was at least alleged to this individual. I would commend you to read the case of the Board of Ethics versus Luis Herrera, 560, 592, in which actually there's issues in terms of trust monies and accounting and things that could have gone really south for Mr. Herrera. As it turns out, he got a reprimand. He didn't get suspended. In following up the comment that you made, Mr. Chief Justice, and you, Justice Wiggins, as well, I think in terms of having his conditions to practice, since this lady has not practiced, since 2013, letters from 3 licensed attorneys in terms of character, integrity, balance, it's good. In terms of having the idea that where do you go, who do you get treatment with, are you taking your medication, are you sober, things of that nature, which we can provide for certain. So there's some oversight going forward. Makes, I think, perfect sense. I think in terms of it's the right thing to do. I think a suspension at this point, after she's been on the bench since 2013, in light of everything that's happened, I think has certainly the prospect to crush her. And I don't think that's the intent of why we have the ethics system. I certainly don't take anything that happened in the past lightly. She doesn't either. She takes complete responsibility for it. But in terms of going forward, if she's reprimanded and has certain conditions to re-enter the practice and the profession, I think she'd make this court proud and the people of the state of Iowa proud. Thank you very much.
Thank you as well, Mr. Brown. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.